Hi, my name is Lauren Haller, and in this presentation I will be discussing the Supreme Court case Terry v. Ohio and its implications. On the afternoon of October 31st, 1963, Officer Martin McFadden was patrolling downtown Cleveland, Ohio in his plain clothes. Officer McFadden had been a police officer for 39 years and a detective for 35 of those years. On this day, he had been assigned to patrol for pickpockets and shoplifters. He noticed two men, Chilton and Terry, standing on a street corner. According to Officer McFadden, he had developed routine habits of observation, and these two men didn't look right to him. He then stood about 300 to 400 feet from the men at the entrance of another store to further observe them. One of the men left this spot and walked down the road past other stores. He looked in a store window, walked down the street some more, and then turned around to walk back to his companion, once again stopping to look at the same store window. Upon his return to the corner, the man chatted with his companion. Then the second man of the pair repeated the same motions, walking down the road, looking at the same store window, turning around, looking in the window again, and then joining with his companion on the street corner. Both men continued to repeat this routine 5 or 6 times each, resulting in about 12 passes between them both. Officer McFadden noticed a third man approach them during this time. They had a brief conversation, and then he walked down the opposite street. The two men then went down the same street as the third man. The actions of the men made Officer McFadden suspicious that they were casing a job. Officer McFadden feared that the men may have a gun and continued to investigate further. Officer McFadden followed Chilton and Terry, the original two men, and observed them stopping to converse again with the third man from earlier. At that point, Officer McFadden approached them and identified himself as a police officer. He had no other information about the men besides what he had observed. The men mumbled something in response to Officer McFadden, causing him to grab Terry, spin him around to face the other two men, and patted outside of his clothing. McFadden felt a pistol in the left breast pocket of Terry's coat and reached inside the pocket but was unable to remove the gun. Officer McFadden, with Terry between himself and the other man, ordered them to enter the store and remove Terry's coat completely to remove a .38 caliber revolver. He ordered the men to face the wall with their hands raised and proceeded to pat down Chilton and Katz. Officer McFadden discovered a revolver on Chilton, but no weapons on the third man, Katz. Officer McFadden testified that he had only patted down the men for weapons and did not put his hands underneath their garments until he felt a gun. All three men were taken to the police station, and both Terry and Chilton were formally charged with carrying concealed weapons. This case went to the Supreme Court of the United States as it became an issue of the Fourth Amendment, which protects against unreasonable search and seizure. The question became, was Terry's right to be protected against unreasonable search violated given the circumstances of the encounter with Officer McFadden? Ultimately, the Supreme Court ruled that the police did have the right to stop a person with whom they had reasonable suspicion of committing a crime. As well, the police are not prohibited from frisking an individual they believe has reasonable suspicion of being armed. The United States Constitution promises to provide for the common defense of the people. In the case of Terry v. Ohio, the police are an extension of the defense of the people. It is one of the founding principles of the United States that the people will be protected, and part of this patrolling and investigation by the police. However, the U.S. Constitution is also set forth to protect the freedom and liberty of the people. Part of this is the right to live without unjust scrutiny by the governing bodies, including the police. Here lies the case of Terry v. Ohio. It falls between the intersection of balancing the defense versus the freedom of the people. According to the Supreme Court ruling, Officer McFadden did act within his constitutional duties to protect the general public, and that any reasonable officer would suspect that the men in the situation were armed. The Fourth Amendment protects people from unreasonable searches and seizures. As a citizen, Terry was certainly entitled to the protection of the Fourth Amendment and the right to personal security as he walked down that street in Cleveland. However, the question is whether or not Officer McFadden's actions were reasonable given the circumstances. The Supreme Court of the United States deemed that the facts and observations available to Officer McFadden at the time would warrant a reasonable person to take those actions of searching Terry and the other men. Although the Fourth Amendment guarantees the right to personal security, there are exceptions to this law, including a search tangential to a lawful arrest. Items left in plain view, consensual searches, and stop and frisk. The stop and frisk exception was established in Terry v. Ohio, where a law enforcement officer can briefly stop and search a suspect. However, they must have reasonable suspicion that a crime has been committed, is being committed, or will soon be committed. In the case of Terry v. Ohio, Officer McFadden was found to have reasonable suspicion of Terry and the other men. Their actions were suspicious, as they all walked past the store window multiple times and spoke with each other as if to case the joint.